Hey everyone, it's Rob Ryder, October 31st, 2012. My email address is courtofrecord@aol.com. The stuff I'll be talking about, the papers and so forth, you should be able to find on robcourtofrecord.wordpress.com later on. The YouTube is Rob Ryder, ROBBBRYDER, and I had to use 3 B's, so it is 3 B's in there. And some of this is kind of a review, excuse me, especially for me. I like to go back and look at things again and again and again. But I came across some interesting information. I thought I'd share it. So what we're going to be talking about are, what's a court of equity? What is the chancery? And, what is equity and what is it not? What legal title is, what equitable title, what in rem, which is equal to law. It's directed towards a thing, and in personam, directed towards a particular person, is used in equity. What's the difference between a unilateral contract versus a bilateral contract? Merger of law and equity, equitable remedy, maxims of equity. Wonderful stuff, right? I know you're all waiting to hear this. But let's start with the foundation a little bit, because there's things I want to add to it, but this will help, I think, especially for a lot of people who may be kind of new to this topic. So the things I found that were of interest were on Oxford University Press on this website. And the link I gave goes to law. And then if you go down to here where it says trust and equity, all these are different kinds of law. If you were to click on each of these, you would find things like this. And so what these are just little different courses taught at Oxford to do with trust, and they have samples of what they are. So foundations of equity and trust is what this one would be. And so the one we're looking at now is, or will be looking at, is The Birth of Equity and Trust, Book 1. You give a lot of book 1s, right? They don't give the other books, but you get book 1, and that's where a lot of the beginning stuff is. Good place to start. So, but I can't read the whole thing. It takes too long. It's like 35 pages long. So I just pulled some excerpts out. But that's going to be that's what we'll be looking at. And I hate to ask, but if you can donate, I would certainly appreciate it if you would. If you were going to mail it, it's Robert Rytlewski, RYTLEWSKI, 10955 14 Mile Road, Rockford, Michigan, 49341. I have been doing my address differently than that, but they don't like to deliver to that address. It's been kind of interesting. So I was using the 11-digit zip code. So, and then if you want to use PayPal, that is my daughter's PayPal account. Her email address is her PayPal account. ASHLEYRYTLEWSKI@gmail.com. Thank you in advance. Okay, so in this book, The Birth of Equity and Trust, like I said, I just pulled out excerpts. You're going to have to go and read the rest if you want, but this is just to build a foundation of the things I'll be talking about later. So in this chapter, we discuss the origin of equity and trust as distinctive aspects of English legal system and the subsequent merger of equity with common law. Okay, so they were distinctive and then they got merged. In order for students to appreciate how equity functions in a modern society, first they need to understand the origin of equity, its individual operation before being merged with the common law, as well as the development of trust, which, as we will see later, took shape in the court of equity. This chapter will also consider the effects of merging equity and common law, a topic that continues to generate debates among academics and judges. And a lot of what's happening to us is because of this merger of common law and equity. And considers whether equity has any relevance in modern society. Well, we're going to make it have some relevance. It is hoped that this chapter will lay a solid foundation for discussion in the second chapter on the maxims of equity and the main tools through which equity expresses its characters and the specific topic of subsequent chapters. Okay, so basically, if asked what is equity, the addressee will likely respond that equity is to do what is fair. It means to do justice. Got nothing to do with money. Doesn't have anything to do with negotiable instruments. Has to do with what's fair and what's just. That it is a body of rules which administered only by those courts which are known as courts of equity. Okay, so it's a body of laws from a court known as a court of equity. But it would be incorrect to define equity as such today because there are no courts that can now be called courts of equity. You're not going to go find a court called a court of equity. But that's the court that handles equity, so we need to find the court that's hiding the court of equity. Equity in the years post 1875, and I remember this is for the UK, so it does have some UK stuff in it. And for UK people, pay attention. This will get kind of interesting. As the body of rules administered by the English courts of justice, which were it not for the operation of the Judicature Act, would be administered only by courts known as courts of equity, describes this part and distinguishes it from other aspects of law by reference to courts that are no longer in existence. Right? So as you can see, they keep talking about what equity is and that it's in the court of equity, yet there is no court called the court of equity. The court that are no longer in existence. We raise certain ambiguities as to what part of equity is now administered with common law. So what happened is back in 1875, whatever it is, they had a Judicature Act, right? And it combined equity and law. And if you were to look at the United States Supreme Court, it has original jurisdiction in law and equity, right? You could take something to them directly because original jurisdiction means you can go directly to them. And the Supreme Court of Michigan says the same thing, that they have jurisdiction in law and equity, original jurisdiction. The problem is I've never seen how to put a petition into either of those. And, you know, when you're going to equity, really you're putting in a petition. It's not a court case. You're putting in a complaint. As you're going to see, you're putting it in the chancellor, and you know. So if they're not easily found, well, it looks to me like in canon law they have a place you can do the same thing because they tell you how to put in a yeah, what the heck is it? A petition. Jeepers. Yeah, how to put a petition in. And they have jurisdiction in real actions, and real actions can only be heard in the Court of Common Pleas according to common law. In England, that is found in Westminster Abbey, right next to the Court of Chancery. So there's a lot of parallels between what happened in England for hundreds of years, and although the courts have changed the name, they're using the same type of process. So continue on here. So did the acts fuse the rules of equity and common law, which undoubtedly used to be administered separately by different courts before 1875, had two different courts, two different set of rules? Or did they simply unify or amalgamate the previously different administrations of equity and common law and entrust this upon the shoulder of a single court? So they're saying that there's only one court that has jurisdiction in law and equity. So, which immediately prior to the coming into force of the Supreme Court of Judicature Act 1873-1875 was enforced exclusively in the Court of Chancery, right? So, equity used to be the Court of Chancery, period. It was the only place you could go. And not in the courts of common law, which were the Common Pleas, Exchequer, and King's Bench. Equity is a means by which a system of law balances out the need of certainty in rulemaking on the one hand with the need of sufficient judicial discretion to achieve fairness in individual factual circumstances on the other hand. So what they're saying is when they write a law, now what I don't know if I put these in here or not, but when they talk about common law in here, they're talking about custom, traditions, and parliament, right, which are statutes. And that makes up the common law, and they call that the law of the land. Because Parliament are all landowners. You ain't. That's why you're not in Parliament. You're not a lord. We're trying to get our lordship. They would write a law, and let's say, well, here's one of them, right? In the statute of uses, they decided that whoever holds a legal title is the owner. Okay? Whoever holds a legal title is the owner. So if you hold the title to something in law, you're the owner. Now, if that's your title and somebody else has it, and they say, well, I have the title, I'm the owner, you have to go to equity, to the court of equity, to say, well, if he has it, he's gotten it by fraud. Right? So I need you to have him bring in the evidence. And then we're going to determine the rights, title, and interest. Right? I'm not looking for money, I'm looking for the property. That's my property. I claim the right, title, and interest to it. And that's what happens in real actions. In the Court of Common Pleas, they take a writ under the Great Seal from the King, from the Court of Chancery, to have a hearing in the Court of Common Pleas to determine the rights, title, and interest for real action. And real actions were for real property, for land. So equity is the means by which a system of law balances out the need for certainty. Okay, I read that one. Equity describes a particular body of law consisting of rights and remedies, which evolved historically through the courts of chancery. Chancery, chancery, chancery. It's all about chancery. For equity, though superior to justice, so equity is superior to justice, is still just. Justice and equity coincide. And although they are good, equity is superior. What causes the difficulty is the fact that equity is just, but not what is legally just. It is the rectification of legal justice. What's legally just is for the guy who holds the title to say he's the owner. Right? Doesn't matter if he got it by fraud. If he has it, he's the owner. That's what the law says. You have the title, you're the owner. Well, if you got it by fraud, you need to go to the Court of Equity, or excuse me, the Court of Chancery, which is a court of equity, and have them bring in the record to see who is actually the owner. Equity is a body of principles, doctrines, and rules developed originally by the old Court of Chancery. There you go. It's all about chancery. In constructive competition with the rules, doctrines, and principles of common law, courts now applied since the Judicature Act, the Unified Supreme Court of England and Wales. So they're saying that the whatever is the Supreme Court of England and Wales, the way I read this, right, is the court that has original jurisdiction in law and equity. If you're in the UK, England or Wales, the term equity is in a general sense associated with fairness, morality, justice. It is an ethical jurisdiction. On the more legalistic level, however, equity is a branch of law that was administered in the Court of Chancery. How many times I got to tell you? The Court of Chancery. The origin of equity can be tracked back to the existence in the 13th century reign in England of Edward I of three distinct courts: the King's Bench, the Common Bench or Court of Common Pleas, and the Exchequer. They had three courts. These courts operated independently, entitling plaintiffs to a choice of the three. However, predominantly they all administered traditional, which is custom, and statute law, which is from legislature, collectively known to the Edwardian lawyer as common law, a collection of legal principles and rules dating back to 1189. It has a long history. However, of these three courts, the Exchequer performed more than just a judicial functions, and according to Martin Land, it served as a government office, a modern-day treasury. So the Exchequer is the same as a treasury. This court is headed not by a judge, but by a chancellor, a person equivalent to the chancellor of the Exchequer in modern-day Britain. So they're saying it isn't the chancellor of the Exchequer now, it's a person equivalent to him. So if you're, in England and you go look up what it says about the chancellor of the exchequer now, you get an idea of the qualities you're looking for in a person who is his equivalent, and it won't be a judge. This court is not headed by a judge, so it says, but a chancellor. So, as a government official, the chancellor oversees many departmental work, such as issuing of writs for the commencement of actions in the courts of law. Even to this day, it is not possible to commence a legal action without issuing a writ of summons or other kinds of writs, depending on the nature of the action, to the defendant. Okay, so if the chancellor oversees the issuing of writs, well, where are the writs coming from that they send to us as a summons? Because the only person that's seen it at the court is the clerk. Right? On a normal summons, the lawyer goes in and does something with a complaint of some kind, but you end up getting some kind of summons that, hasn't been lawfully sent to you because the judge never signs it. But it has been seen by the clerk of the court because there's seals on it. Right? So could she be the chancellor? Could be. When issued by the chancellor, these writs are sealed with the king's seal. Okay, so when issued by the chancellor, okay. So I don't think I don't know if the chancellor always issues them or not, right? Issues the writs. So, but we're just going to read what it says. When issued by the chancellor, these writs are sealed with the king's seal. Well, if it's got the king's seal on it, you got something. Evidently, the chancellor occupies a very important position. He sits in a court, although he is not a judge, issues writs to other courts, and this places him above the judges. And what is more, he is the only one who can encrypt the writs with the king's seal, a symbol of monarchical authority. Well, in Lord Coke, it talks about when you're looking for your privy councillor, you need to find the guy that has the cipher. Right? And ciphers are used for coding, and that's what encrypting is. And, so there you go. He can encrypt it, so he has the cipher. Got to find the chancellor. Although the chancellor issues writs already known to English legal system, he, however, could issue writs to cover cases which were not catered for by the existing writs. Yet, not being a learned man himself, he often found such writs quashed by the courts, especially as he often could not have the benefit of the defendant's claim. I'm going to say it's more because he didn't have the benefit of the defendant's claim, because we're talking about the chancellor, who was the bishop, who's probably the smartest guy in the kingdom back in the 11th, 12th, 13th, 14th, 15th century. Probably to this day. The fact that innovative writs issued by the chancellor are subject to being quashed by common law courts must sometimes distress him. However, like a good card player, the chancellor holds another ace. Although the courts of common law dispense justice, there is also room for the king himself to do justice, even if only occasionally. And that's why they say the chancellor is the keeper of the king's conscience. If the courts do not satisfy the claimants, they simply go to the king. But towards the end of the 13th century, these extrajudicial petitions were so many as to involve the chancellor as the king's prime minister in the direct administration of these types of cases. And it must be emphasized he is involved in the king's council as well. It should be noted that it is in the administration of justice, through or under the auspice of the king, that the chancellor began to develop his judicial power. So when all this was happening back in the 11th century, 12th century, 13th century, the chancellor was always the bishop. And he sat on obviously a very important person. He has another ace. the king himself to do justice, and the chancellor was the keeper of the king's conscience. And so the king gave them the work, and they did it on an extrajudicial petition. It doesn't say anything about doing a court case. You just need to put in a petition. The office of the chancellor is to correct men's consciences for frauds, breaches of trust, wrongs, and oppressions of what nature soever they be, and to soften and mollify the extremity of law. As the chancellor began to operate justice through the king, a division between two forms of justice ensured, as noted above. In the first category, several people petitioned to and against the king. It must be pointed out that some of the kings at this time were great wrongdoers. They were notorious for seizing people's lands without apparent justification. And they did this because they knew their subjects could not seek writs against them in any court, let alone before the king themselves. So what the chancellor did was to devise a means by which, if a case involved the king, the plaintiff from whom land is seized petitions the king, the chancellor sends the case down to the king's bench for trial, and there should the need arise for the plaintiff to prove facts of ownership of land, a jury is assembled to deal with the case. And that would have all been done by going to the chancellor, taking your complaint to the chancellor. It must be borne in mind, however, that this particular form of action deals essentially with legal issues, as between two parties, one of which is pertaining before the king because he is not satisfied by the court, or as between one party who petitions against the king for the later's own wrongdoing. Sounds like a plea of the crown. Chancellor sends a case down to the king's bench for trial, and should there arise a need for plaintiff to prove the facts of ownership of land, the jury is assembled. Okay. But again, it started with a petition to the chancellor, not a court case. Okay, not satisfied. It was not until got some Common Law Procedures Act, granted limited powers to award injunctions, while 1858 Chancery Amendment would empower the chancery to award damages, because damages normally go with common law, and in equity you're not necessarily looking for money, right? You're looking for specific performance. I don't want the money, I want the damn title to the property, right? I want my land. So and they can issue a writ of quorum warranto, they can issue a writ of mandamus. Right? And we've tried these things before, and I'm saying there's a place they can issue them for you that has the power of the Supreme Court. It's the Court of Chancery. As a court of equity. In that great age of poverty, ignorance, bribery, corruption, not many litigants could afford to seek remedies in courts of law. They are sometimes old and pitched against rich and famous, the powerful and celebrities of the day. So much plaintiffs would rather send their petition to the king through his chancellor to do what is right, as the saying goes, for the love of God in the way of the charity, in the way of charity. But as is well known, by this time in the 14th century, the common law courts were so conservative that any such writs which deviated from the laws and practices of the day were regularly quashed. So one may be poor and his poverty written on the writs of the old and the aged inscribed on there, and they did not sway the court. It didn't matter if he told him, hey, I'm poor, I need some help, court of common law. The dictum of common law, it must always be remembered, is let justice be done even if heaven must fall. Let justice be done even if heavens must fall. Right? If the other guy has the title and you don't complain about him having it by fraud to the court of equity, then the law is going to let him have the title. Who's holding the title to your house, right? The title company. What do they got it for? As long as they're holding it, they're seen as the owner. However, the chancellor had an alternative. Instead of sending a piteous plaintiff to the regular courts where his writ might be quashed, he could, after listening to the plaintiff's complaint, order the defendant to appear before him. He does this by issuing a subpoena, not a summons, a subpoena, which orders the defendant to appear before him or forfeit a sum of money. Subpoenas are issued just as ordinary writs to make persons appearing before the chancellor. They are in fact distinguishable from writs. Whilst writs merely inform the defendant as to what action is against him in a court, such as a show cause summons, a subpoena forces him to appear and respond to the plaintiff's claim, and this he must do upon oath, unlike with writs. Indeed, the whole process is subpoena. The oath makes the procedure more like a chancellor, before the chancellor, more like an ecclesiastic procedure. Right? So, it's an ecclesiastic procedure when their oath is involved. Again, the bishop, the diocese, they got a chancery. Rather than mirroring the day's English judicial process, although, as some have observed, if the chancellor were to be asked of his intercourse about his intentions, he would likely deny that he deliberately set out to adopt different judicial process from the ordinary courts of the land. This might be true if it is remembered that the complaints that come to the chancellor normally issues tried by the courts, right? The courts had their chance on it, they messed it up, so now the chancellor's going to do something about it. The extraordinary justice dispensed by the chancellor began to attract bitter and rapid criticism from lawyers. Go figure. Can't make any money if they're following the law. Parliament was angry. They couldn't steal your property. The courts were irritated. The chancellor was giving justice to the poor. For God's sakes, he's giving justice to the poor and to the indolent, as common law courts would regard these people. And at the same time, the king was dispensing controversial justice to criminals. You pointed out fraud. You got your property and put the sumbitch in jail. Controversial justice. Wow, somebody else going to jail besides, the plaintiff who falsely accused you just went to jail is what they're talking about. This double assault, shall we say, on common law courts and the courts of the land, which is Parliament. Luckily, by the time the chancellor was rebuffed by the common law courts, he had already begun to enforce breaches of trust, a system which he carried over from the ecclesiastic church, which would normally punish breaches of such trust by spiritual censures such as excommunication. We can make them do the right thing. They're baptized. Whether they like it or not, they're under the jurisdiction of the Pope, and he can excommunicate them. The common law courts, when they're excommunicated, it's not the church that burns them as a heretic for excommunication. That's what common law does. Right? The Catholics burned heretics and the Protestants burned witches. I wonder who the witches were. The common law courts, with their difficult and conservative procedures, could still not deal with fraud, accident, and breaches of confidence, right? Common law can't deal with fraud. Don't ask me why. They're telling you, though. And a breach of confidence, a breach of trust, a breach of faith. You need to go to a court of equity. The chancellor had consolidated his jurisdiction by issuing what is called common injunctions. The chancellor issued common injunctions to restrain the parties from continuing their action in common law courts, or where these have been concluded, from enforcing the judgment obtained. Right? So if they're taking your property and they haven't signed the deed of trust, well, it's a deed, and right now it's only a unilateral contract because the trustee, who you're supposed to have it with, the trustee is the grantee on a deed of trust. So whether him or the bank, neither of them have signed it. Nobody has signed the damn deed of trust, so it's not lawfully binding. And they're trying to enforce it on you. And they're saying because they hold the legal title to the house, right? The title company has it. Well, they're holding the legal title. They're the owner. Well, how come they have it? Well, they're supposed to have it because there's a lien. Well, then I demand they bring in the lien so we can determine the rights, title, and interest. Underlying these common injunctions is the need for the chancellor to be able to enforce his powers of trust against the rich and powerful who could buy the court, but not the equity. Hence, if despite breaching trust a defendant obtains a judgment, the chancellor does not convert the judgment, he does not annul it, he does not question the legal validity of the judgment, he lets the thing go through. All he does is appeal to the party's conscience against enforcing the judgment against the party appearing before him. Of course, this is a threat, more like, if you enforce your judgment, you shall go to jail. That's what the chancellor can do. So if somebody gets something from you by fraud, the chancellor can look at it and say, yeah, fraud's involved, get a hold of the guy who committed the fraud, say, get the property back, or you're going to jail. Stop what you're doing now, or you're going to jail. Right? Writ of quorum warranto, writ of mandamus, and whatever the prerogative writs are of the king. The defendant petitioned the chancery on the basis of the judgment was obtained by fraud. Okay, so they're talking about a particular case. This happened like 1616 or something like that, and it had Lord Coke involved and a chancellor. Francis Bacon was the attorney general, and they did this on purpose so it could be determined once and for all. You know, who was the top dog? A court of justice or a court of equity? And it turned out that the decree in favor of chancery, the court of equity. Of course, the grant or refusal of specific performance remains a matter for judge's discretion. There are no binding rules, but this does not mean they cannot be settled principles founded on practical considerations. Right? What's a consideration? When you sign your name to a piece of paper as a seal, that's a promise. That's consideration. That's called good consideration. Much better than valuable consideration. Now, if they don't sign the contract, they haven't given you the same consideration. Therefore, you don't have a contract. The appointment of 1729 of the Master Rolls, who's the chief chancery master, to sit as second judge in certain cases, had done little to reduce the burden of the chancellor because the decision of the Master of the Rolls could still be appealed to the chancellor. It wasn't until 1833 the Master Rolls had a true concurrent jurisdiction. In 1813, a vice-chancellor was appointed to assist the chancellor and the Master of the Rolls. So now they had three guys doing it instead of one. And we're just going to quick go down to what the Keeper of Master of the Rolls and Records of Chancery of England, known as the Master of the Rolls, second most senior judge in England and Wales, after the Lord Chief Justice. The Master of the Rolls is presiding officer in the civil division of the Court of Appeal, right? So he has a court that and serves as the head of the civil justice. So you can take it to him. He's got the same power as a chancellor. The first record of Master Rolls is 1286. Those believe the office probably existed earlier than that. Master Rolls was initially a clerk responsible for keeping the rolls, records of the Court of Chancery, also known as Keeper of the Rolls of Chancery. The keeper was the most senior of the dozen chancery clerks, and as such occasionally acted as keeper of the Great Sealed Realm. The post evolved into a judicial one with the Court of Chancery as the Court of Chancery did. The first reference to judicial duties, 1520. So there you go. The Master Rolls got some power. It exists today. So thus in Edward some case, Lord Campbell had to remind litigants that a trustee is accountable to beneficiaries of his trust in equity. Right? If a trust is involved, the beneficiary has to go to the Court of Equity, which is the Chancery, because it isn't at common law. There is no accountability. No action at law for money. No action at law for money had and received can be maintained against him, though he has money in his hands and under the terms of the trust. He ought to pay over to the Sestake Trust. Who's the beneficiary? Sestake Trust is the beneficiary. Sestake Use is the trustee. So as the settler, when you give it to the trustee, the Sestake Use, you gave him legal title. Well, now he has legal title to the property, and if he doesn't do it, he can say, well, I have the legal title. The law will find with him. need to go to a court of equity. The Supreme Court of Judicature, which established with concurrent jurisdiction to administer the rules of equity and law within Uniform Procedural Code. So the Supreme Court of Judicature was established with concurrent jurisdiction to administer the rules of equity and law within a Uniform Procedural Code. Well, canon law is a procedural code. And they have stuff in there for both law and equity. I'm not saying that the Supreme Courts might not be, but, you know, we need to find out where the courts of equity are. Their Judicature Act established a Supreme Court. There we go again, right? The High Court, which is to sit as the court of first instance, well, they call the bishop the judge of first instance, was divided into the Chancery Division, King's Bench. It was divided in each of these. Each these divisions headed by a judge. I wonder if the same judge heads them all. Right? Maybe there's just one judge that heads them all. Not that each one has its own. There's one judge over all of them. And we know that by virtue of Article 24 of this Act must recognize and give effect to legal equitable rights, claims, defenses, and remedies. One of them is the Master of the Rolls. And that could be the same as our Registrar of Chancery, as far as that goes. They kind of have the same functions. The function of common law is to establish rules to govern the generality of cases, the effect of those rules being to recognize that certain persons will acquire certain legal rights and powers in certain circumstances. Legal rules allow the holders of legal rights and powers to exercise them in confidence that they are entitled to do so. The function of equity is to restrain or to restrict the exercise of legal rights and powers in particular cases, whenever it would be unconscionable for them to be exercised to the full. Legal rules allow holders of legal rights, if you have the legal title, you can exercise them in confidence in a court of law. If they're doing that to you and it's being done by fraud, your only defense is to go to a court of equity. The main object of the Act was to assimilate the transaction of equity business and common law business in different courts of judicature. It has been sometimes inaccurately called the fusion of law and equity, but it is not any fusion or anything of the kind. It was the vesting in one tribunal of the administration of law and equity in every cause, action, and dispute which should come before that tribunal. I keep talking like there's only one court that does this. We're intended to achieve procedural improvements in administration of law and equity in all law courts, not to transform equitable interest into legal titles or to sweep away altogether the rules of common law. Right, so they're not going to take your equitable title and make it legal title, right, unless you make them. Such as the rules that the plaintiff in the action for conversion must have possession or right of immediate possession of the goods. So this is common law. Here's the rule. The plaintiff in an action for conversion must have possession or a right to immediate possession of the good. Okay, so the deed of trust. Somebody's got it and they want to convert it. Well, if he has possession, he can. If he's got a right to immediate possession, and how would he have that? Well, they'll foreclose on you, I guess, by providing for the administration of two systems of law by one Supreme Court. One Supreme Court again. Okay, so more recently, judicial opinions in the English courts have tended to favor the fusion of rules approach. In 1993, somebody decided whether the plaintiff who had acted illegally could assert a claim to an equitable interest in land through resulting trust. Okay, so somehow they illegally are asserting they have an equitable interest in land through a resulting trust. As will be seen in Chapter 2, one of the strongest maxims of equity is that he who comes to equity must come with clean hands, meaning a claimant who wants to seek an equitable remedy must not have done anything to tarnish his or her conduct. In the instant case, the claimant had tarnished her conduct by acting illegally. And, we don't have Chapter 2 to see what the whole thing is. At common law, so that's an equity. At common law, the approach is that anyone who wishes to assert ownership of property, the acquisition of which was tainted by an illegal conduct, can do so, insofar as the claimant does not rely on the illegal conduct. They're going to rely on the fact they got the title. I'm not going to say we got it by fraud. You got to tell them they got it by fraud in a court of equity. To draw a distinction between property rights enforceable at law and those which require intervention of equity would be surprising. More than 100 years has elapsed since the fusion of administration law and equity. The reality of the matter is that 1993 English law has one single law of property made up of legal and equitable interest, although for historical reasons legal estates and equitable estates have differing incidents. The person owning either type of estate has a right of property, a right in rem, not merely a right in personam. So they have a right for the thing and a right by the person. If the law is that a party is entitled to enforce a proprietary right acquired under an illegal transaction, in my judgment, the same rule ought to apply to any property right so acquired. So no matter how whether it's any property right. Well, what's property rights you got? You got equitable right and legal right. So acquired, whether such is legal or equitable. Okay. So if the law is that a party is entitled to enforce a proprietary right acquired under an illegal transaction, in my judgment, the same rule ought to apply to any property right so acquired, whether such right is legal or equitable. Doesn't matter how they got the right. They're going to be able to take it to a court of law and say, well, we got the paper. Right? That's what they're showing, that we have the title. And it's because you deposited it with them. Right? When you deposit money in a bank, you just gave them legal title to it. When the warranty deed or anything else goes into the Register of Deeds office, that's being put on deposit with the county. No doubt our task nowadays is to see the two strands of authority at law and inequity molded into a coherent whole. But for my part, I cannot see why this amalgamation should lead to the rejection of equitable proprietary right. Okay, so it still exists. The law does not operate on the basis of emotions or assumptions about the parties intended to do or achieve in any situation as against what they actually do. This is why the common law is often regarded as unduly rigid. The problem, however, is that once the law begins to get involved in trying to discover the intention of the parties, it may accidentally open Pandora's box. Once a case does not fall within the legal perimeters of the law, it is the business of equity to attempt to make sense of the issue involved. The common law courts have traditionally not functioned in this respect, and it may be precarious if they encourage to undertake such tasks that only equity courts perform. Just certain things can only be done in equity. It's an extrajudicial, right? If they were to say, well, all these cases have fraud, right? Then it would overturn the apple cart, and they're not going to do that. They're going to make you go find out what's going on. So in New Zealand, appeals court had to deal with the issues concerning whether damages, which had traditionally been a common law remedy, should be made available for breach of trust, which clearly is an equitable duty. So breach of trust, breach of faith is equitable, court of equity. Petition to the diocese or try the Supreme Court or call around and say, where is the court of equity? In another court case, breach of an equitable duty can lead to an award of exemplary damages or damages for mental distress. Traditionally, this remedy was only available in common law courts. Well, now, whatever this court is, this Supreme Court has jurisdiction in law and equity. So it can look at what's happened and say, yep, you're right, and not only are you right, because this guy committed fraud, here's 3 times damages. There might be room for concern if one were indiscriminately attempting to meld the whole of 2 systems. Equitable concepts like trust, equitable states, and consequent equitable remedies must continue to exist apart, if not in isolation, from common law rules. They don't mix. Can't get equitable remedy from a court of law. You can only get it from a court of equity. The defect of our legal system was not that law and equity existed, but that if a man went for relief in a court of law and an equitable claim or an equitable defense arose, he must go to some other court to begin afresh. Law and equity, therefore, would remain if the bill passed, but they would be administered concurrently, and no one would be sent to go from one court for relief which another court had refused to give. Right? So the idea was, doesn't matter what the law says. Yep, you're right. The trust company's holding the trust. Or excuse me, the title company's holding the title. So they have legal title. However, you're telling me there's no reason for them to have the title. Well, then the chancellor's going to say, well, let's bring the records in and see who should have the legal title. The only reason for the title company to have it is if there's a lien against the property. Well, the lien had to have been recorded. If it hasn't been recorded, give me back the property. It is still clear that legal ownership is different from equitable ownership. All the previous provisions of legislation, 1925, dealing with unregistered land are based on the assumption, again, the law of trust assumes a distinction between legal and equitable rights. More on that later. Okay, so this was the Master of the Rolls. What else was there to tell you about the Master Rolls? Oh, there wasn't so much. But I want to talk about the Court of Faculties real quick, because before I forget, this is what the Archbishop of Canterbury's seal looks like. Alright. Well. So anyways, and this comes out of the Court of Faculties, and this is the equivalent in England to our certificate of authority for a notary. So more on that in just a second. We'll come back if I got time on this thing. Wrong one. The Court of Faculties is a tribunal of the Archbishop of Canterbury and is attached to the office of Archbishop of Canterbury, right? Ecclesiastic law, all right? The jurisdiction conferred upon the Archbishop of Canterbury by the Ecclesiastic License 1533 is exercised by the Court of Faculties. This includes the appointment and removal of notary publics. Notaries are under the jurisdiction. They come under the Archbishop. And the granting of those licenses and faculties which are the concern of the Archbishop of Canterbury, such as special and ordinary marriage license. Lambeth degrees are also conferred, and Master of Faculties is appointed by the Archbishop, subject to the approval of the Crown, is also the Dean of Arches. And the Dean of Arches is an interesting guy too. So anyways, this is just one of a guy did in England some time ago, Laws. I lastly certify that as a notary public, he is duly qualified to grant and attest contracts and all other deeds, and full faith and credit are due to his official acts. Well, we get something similar to this, but it comes from the county clerk. So is the county clerk the same as, right, the Court of Faculties? I don't know. Something to think about. So, anywho, again, if you could donate, I'd really appreciate it. There's the information one more time. I won't say any more about it. And as far as these other things, we'll get to them in some separate books. There's just too much to try to do in one video. So, Hope you found it useful, and I'll post this shortly. Have a great day. See ya.